Looking at criminal law through a psychology perspective helps open the door to possible reforms. Right now, a particularly gray area is unreliable informant testimony. This usually comes from a jailhouse informant who's either bribed or incentivized by the prosecution to testify in court. And this jailhouse informant is usually in contact with the suspect while in jail. They can take statements or even a secondary confession, which may or may not have been heard by them. The secondary confession is not a direct admission of guilt, and that's important to remember because whether or not it was true or the jailhouse informant actually heard it, the jury will. And the jury is very persuaded by the secondary confession. Jailhouse informants are so persuasive to a jury that their false testimony is a leading cause in wrongful convictions in capital cases, and that's from the textbook. However, juries are also typically unaware of the incentives that the informant is receiving to testify. They probably typically think that it's out of their heart or goodwill that they're doing this, but typically they're on death row and have nothing to lose. So any sort of plea bargain or incentive or offer of parole is a godsend. They'll do anything for that, including throw their friends under the bus. Some of the research conducted and explained in this book is done on the jury, and they were seeing whether or not their guilty verdicts would change based on information presented at court. Some of the variables were finding out the informant's incentives to testify, revealing their testimony history, so whether or not they've testified in court against a suspect or not, and also presenting an expert testimony witness. And all of these found that their guilty verdicts didn't change, which is interesting because when thinking about reform, those were probably the go-to topics that I would have said would make a difference, and they didn't. What's also very alarming about all of this is that early on in the textbook it explains that the existing safeguards against unreliable informant testimony are inadequate, which means they're doing something wrong. And I believe that starts with incentives. If they're offering incentives to informants in the jail on death row, then obviously they're going to take the incentive. They're going to do anything they can to get out of their situation. So incentives should be offered after the trial. They should be given an opportunity to come forward with any evidence if it's real. And if it is, then they can testify in court. And if there's a conviction, then they should be rewarded for coming forward. But they should not be given an incentive before the trial. Currently, there is no real solution to unreliable informant testimony. Therefore, putting the incentive at the end of the trial could potentially be a very important research experiment to conduct in the future. As for problems arising, I could potentially see that the prosecution would have a difficult time finding informants to agree to this, especially after they know the normal routine of getting an incentive before the trial. But applying this now could be great for the future and decrease false convictions. A final reform would be to allow jurors to use a flowchart to be able to understand the instructions they're given better. The results of research on this have been mixed. However, because they're mixed, there's also a positive side to them. The only potential downfall with using a flowchart I could see would be that jurors lose focus on the actual trial taking place by looking at the flowchart or not looking at the flowchart enough. However, having that aid could potentially help them and reduce false convictions.